The Economic and Financial Crimes Commission (EFCC) made the news as the Supreme Court has reserved judgment in the suit filed by 16 states challenging the constitutionality of the laws establishing the EFCC and two others to a date to be communicated to the parties. At the resumed hearing, Imo, Bauchi and Osun states joined the suit as co-plaintiffs, while Anambra, Ebonyi and Adamawa states announced their decisions to withdraw their suits. The trio's suits were struck out, according to the court. The Attorney General of the Federation, Lateef Fagbemi, who was present in court as the defendant, had craved the court's indulgence to take the process they filed. Justice Uwani Abba Aji thereby granted leave to the defendant to use the reply on point of law filed on Tuesday. Reacting, the Attorney General of Nasarawa State, Labaran Shuaibu Magaji, noted that its appeal is to seek the justice's wisdom on the policy of cash withdrawal limit by the state, which would affect the limit standard of the indigene, and not to question the Constitution.
The case for Nasarawa State is completely different from that which Kogi and other states are before the Supreme Court. Nasarawa State is happy with the establishment of the EFCC, ICPC and NFIU. But our own case is challenging the constitutionality of the directive issued by the NFIU, limiting cash withdrawal for states, knowing fully well that in Nasarawa State we have a social investment policy geared towards enhancing the living standard of the people at the grassroots, where His Excellency the Governor Engineer Abdullahi A. Sule, out of his passion for lifting people out of poverty, initiated a program through which indigent people at the grassroots level are being shared some stipends running into millions of naira, and is the talk of the states, and the entire people of the state are very happy with that. Now, by the time this policy comes on board to limit the cash withdrawal by the states, it will frustrate this program, and it by extension affects the living standard of the people at the grassroots. So this is why we are in court, not to challenge the constitutionality of the establishment of the EFCC, ICPC, NFIU. These are institutions that are in place to actually fight corruption that is bedeviling the development of this country. So Nasarawa State is still on its feet, seeking for the interpretation of the Supreme Court on the constitutionality or otherwise of that policy. This is why we are here.
Recall that the suit marked SC/CV/178/2023 was originally brought before the court by Kogi State. However, 15 other states applied and were joined as co-plaintiffs, while others filed applications for their own suit to be consolidated with the extant matter. The states are basically challenging the legality of the operations of the EFCC, which they insisted was not validly established by the then administration of President Olusegun Obasanjo.